here. Live stream isn't enabled in this group. To enable open group settings.
Are we live anywhere?
Yeah, we're live on Instagram. Are we coming from Instagram?
It's not showing.
Okay, let me just check something. We're not live on Facebook. We're live on LinkedIn, though. Oh, Lord. And we're live on YouTube. So, guys, if you can hear us, give us a second with a technical.
Let me have a look.
Open your group settings.
Oh, yeah, I can see us live on.
Hello, everybody. We are just setting ourselves up. This is our first time doing this, so bear with us for 1 second.
Sorry, I'm having a glitch.
And right, groups both live videos, events. Click add and try again. Give me 2 seconds. We're just trying to syndicate. Is that the word? No, I had to normally do this. It's normally done automatically. So, group settings.
No worries, no one's there yet. So that's fine.
Posts.
Okay, we have 3 people here.
Yeah. It's all good.
Just having some technical issues, but they'll be sorted very soon.
We'll be with you in a jiffy.
So at the moment, it's just live on LinkedIn.
It appears to be.
It's not live on Instagram or Facebook?
Instagram is live, yeah.
Okay.
Can you see it on Instagram?
Let me have a look.
And we are trying to get live on Facebook, and we're good.
So I don't see it live on Instagram.
Ah, okay. Give me 2 seconds then. Group settings and post formats. If not, we might just scrap the Facebook and just continue. Give it 1 more minute. I've never had this problem ever.
It's new. It's the first time we're using this, isn't it?
Yeah, but it normally just does it automatically for me. That's the reason why I use this software. But that's no one else's problem. That's our problem. Settings. All right, I think we're going to have to scrap Facebook, unfortunately, which is really a shame.
Yeah.
But what it's telling me to do and what I'm seeing is 2 different things, and we're wasting time. So
okay,
let's just start. Let's just go for it. Okay. All right. So hi everybody. My name is Richard. This is Sonia. Can you introduce yourself?
Hello, I'm Sonia.
So we are. Well, I'll put to you, Sonia. I'm going to let you run the show. I'm just going to talk when spoken to.
Well, it's just a little chit chat. So right now, me and Richard are looking to like grow the business, and I've been have been given opportunity to work on marketing. So I don't know if you've probably noticed, but I've made a few posts on LinkedIn over the course of a few weeks, and Richard has shared some of those posts that I've also made. I just make posts on like LPAs, trusts, digital vaults, wills. And I've also started moving a lot of the marketing to Facebook and Instagram. So I've just been posting a lot of quizzes on Instagram. So please check out our Instagram at Once Wills and Trusts. And yeah, take part in the quizzes, please. It's actually fun as well. And on Facebook.
Awesome.
So I just wanted to ask Richard a few questions just regarding inheritance tax. So let's say someone has an estate of over 500,000. They haven't done any type of estate planning whatsoever. What's the first piece of advice you would give to them?
Speak to an advisor, But outside of that,
Yeah.
It's important to assess the estate, basically have a decent will in place. That's the fundamentals.
But why would they need a will?
Lots of reasons. So it depends on the family dynamics. So you've got different scenarios, we call blended families, of different situations. Everyone's got a different family scenario. If those who are not married, but are living together as a family, that's going to have a big impact on the tax planning. And then making the decision, how do you want to leave the gift? What is your plan for the family? Are there children from other relationships or not, besides the children you have in the current relationship? Is the dynamics healthy? Is it not healthy? Is there people you want to leave in your plan or not? If your children are under the age of 18, if God forbid something happens prematurely, unexpectedly, who would have parental rights over your children? That needs to be in writing. If not, then the local authority will take over that responsibility. They may not be in line with your wishes. So all these things a will can help you to do, and we'll discuss that. And then we're going to look at the type of asset, how the property is owned.
Yeah.
Did someone put more money in it than the other? Was it inherited? And if one party passes away first, what's the plan? Will the house be sold? Will it be passed over to one person to manage? If you've got children from other relationships, do you want to make sure that they are looked after and cared for as well, or not? So all of this is part of the mix. So really, I call it a wealth plan rather than a will, because it's just how do you want to preserve the wealth? And then we discuss the estate planning rules or the tax rules around that, based on what the goal is for the family, because every family's got a different plan. Not everyone wants to build generational wealth, and that's respected, but some people do. And so from there we can go details, and answer questions, and create a bespoke piece of work, I guess, for the family, so they've got absolute peace of mind that whatever they want to see happening within reason will happen. So and obviously review it, but that's the long and short of it, really.
So would you say creating a will is like the gateway to creating generational wealth then?
Definitely, because what we would do, we allow trusts within wills, and the power of a trust will allow you to determine who, not just who gets the wealth, but how it's distributed. So there's two ways of making a gift. You can make a gift directly, which in my personal opinion is probably the worst way of doing it, or indirectly, utilizing the trust, for example, so your voice is still heard even when we're no longer here. So
is that where the use of the trustees come in, where they manage?
Yeah.
Okay.
Absolutely. So just for those who don't know how trust works, the person who owns the assets will be the one that creates the trusts. So they're called a settlor historically. And then the ones who manage the trusts are known as the trustees. And then the ones who benefit from the trust are known as the beneficiaries. And so, so basically the trustee's role will be to manage the property on behalf of the beneficiaries. And then the settlor would create something called a memorandum or letter of wishes, expressing what they would like to see happen, so the trustees can use their discretion to make that happen if possible, and use it as a guideline for the family and for making decisions long term, really.
Okay, so can I give you a little scenario then?
Yeah, go for it.
So let's say these siblings, they share a property, they have the property in their name, but they don't live in the property, one of their family members do. Could you tell me about who the settlor, the beneficiary, and who the trustees possibly are in that scenario?
So just repeat the question, sorry.
So we have two siblings that own a property, but they don't live in a property.
They don't live in the property.
They don't live in a property. A family member does.
A family. What's the dynamics of that family member? Is it mum, dad?
It's a parent.
Parent, okay, yeah.
Can you just describe the relationship between like the settlor, trustee, beneficiary, the benefits, and probably the drawbacks of that?
You picked a really complicated scenario.
Did I?
Right,
let me change it then.
I'll answer the question.
Okay.
But All right. So the person who created the trusts is a settlor. So I've got to establish who created the trust.
Mhm.
So let's say, for example, you said there's a parent living in the property,
Yeah.
and the parent provided the deposit to buy the house. So that they gifted some money to make the house, to buy the house. So we
Mhm.
call them the settlor.
Mhm.
But their name's not on the house. Is that what you're saying? Or is it
Their
on the
name's
house?
not on the
It's
house.
not on the
They've
house.
gifted it. Well, I don't know if they've gifted it, but they want their children to have ownership of the property.
Okay. So I think we should make the example simple so everyone can get it, and then we can get more complicated. So if we said, for example, the parent lives, or mum lives in the house,
yeah,
and she wants to gift it to her 2 daughters, for example. So she's got a choice. She can gift it directly via the will, but when she eventually passes, she can gift it during her lifetime, but that's going to have some complications. Or she can gift it via a trust, which means it's not going to affect her children, but they do have the right at some point in the future to benefit from it if they choose to. Does that answer your question? No. Yeah. So long as sort of your mum could live in the property, she'll be the settlor because it's her property. So she literally gifted it into trust. Let's assume there's no mortgage, so the legal title and the beneficial title is put into the trust, and then she wants to ring fence that and protect it, and assuming that she's healthy and there's no challenges, and her main priority is to benefit her children, then the trust is valid, and so the children will be named as the beneficiaries. And if it's a discretionary trust, there's different types of trusts. So a discretionary trust is one where the trustees have 100% absolute discretion to make decisions. So we've got 3 hats or 3 offices. So the settlor could be a trustee. The settlor will be a beneficiary. So literally she'll be, one day she's a settlor and creates the trust, then the rest of the days she's a beneficiary. She could also be a trustee, which more than likely she would because she lives there, to help make decisions, and then maybe one other person or up to 4 people can be a trustee. So they would have a joint management meeting, shall we say, to decide how things would go with regards to the decision of maintaining the property.
All right. Well, thank you.
It's all right.
All right. I'm just throwing questions at you now, aren't I? I'm just thinking. So you know how, like, I don't even know if it's this day and age, but a lot of people want to own multiple properties. Just because it would be an extra source of income. They can rent it out to tenants and generate income that way. So, let's say someone who has about 2 or 3 properties, but they want to avoid inheritance tax. What advice would you give to them in relation to their properties and avoiding inheritance tax?
It's a tough one, Sonia, because so they're concerned about inheritance tax. So the first thing we'd look at is, well, how big is their estate? But then, see, landlords and property investors have a challenge when it comes to inheritance tax. There's certain things you can do depending on how much they're willing to invest to make that happen, and how much time they have to make that work as well. So to give it a generic answer, because obviously everyone's situation is going to be different. You can use a trust, but the challenges with landlords and trusts is that trusts have a limitation as to what you can put in there tax-free, and they have a time scale as to how often you can put funds in the trust. So if a landlord has a portfolio of, say, 5 properties that amount to, let's call it £500,000, just for argument's sake, then the maximum he can put into a trust within a 7-year period without being taxed up front, and that's a conversation that we'd have to have, and you have to speak to a tax professional to make sure that the tax implications are not too heavy. Then the maximum you could transfer into that trust during his lifetime, or in his lifetime, is £325,000, for argument's sake. And then the clock will start ticking, and then 7 years will go, and then it will refresh after 7 years.
Yeah.
And then you can put another £325,000 in. So someone who's trying to reduce their inheritance tax liability, maybe £500,000 for example, if you've got a large portfolio of a couple of million, how many 7-year blocks do you have to wait before you get under the threshold of £325,000 if a death event takes place? So it's a very long-winded way of reducing tax. You could just make an outright gift and survive 7 years.
Okay.
So you could gift as much as you like, but again, if someone passes away within that 7-year period, the liability of inheritance tax will be on them to pay it. And if you're trying to reduce the liability, then it's going to be again, age is a consideration, and that will affect the type of advice that someone would need. So it's a very wide scope. It's not a cookie cutter kind of answer. It's just a generic, what problems could arise. So therefore, we have to use different type of vehicles for landlords to look at reducing or mitigating any inheritance tax. And also, the problem with landlords, unfortunately, that if they're using limited companies, then they're deemed as investment based businesses, and so they can't claim any relief. So it makes it very difficult. If they're property developers and they can prove it, and there's no investment business, but only development business, and obviously it's a lot more favorable, but it needs to be validated that they are trading or not investing. So there's a lot that goes into planning for landlords, but it's important they do it sooner rather than later, so that there's no complications down the line, really.
Okay. I'm going to ask you a bit about probably an LPA. Is that okay?
Yeah, go for it.
All right. So obviously we know about the health and welfare LPAs and property and financial affairs LPAs.
Yeah.
Can you tell me a bit about business LPAs?
Okay, so business LPAs are property and finance LPA, lasting power of attorney, but we'd normally draft them to assist the donor if their business, so whoever runs their business is separate to the family members. So normally the family members may not understand how the business runs, whereas there may be key people within the business who do know how the business runs, and so they could run it without the owner being there. But if that authority was left to family members, they might run it to the ground, and so the donor, the person who creates the LPA, would be very concerned about that, and so would want the key people in the business to have the authority when necessary to make the right choices, such as accessing bank accounts or making certain decisions to do with the finances of that business. So then set up a business lasting power of attorney in order for that to give them that autonomy or leeway for property and financial decisions specific to the business only, nothing else but just the business or multiple businesses if the instructions are given in that particular document. So that's basically what so we just give it the term business LPA. It's a property and finance LPA just directed specifically to business owners with their businesses if they don't believe that their loved ones could run that business or have an understanding of how the business is run in the right way.
Yeah. And probably for those that probably don't know exactly what an LPA is, do you want to say like a definition for it, just in case they might not know?
Sure. I mean,
exactly.
lasting power of attorney. So the long and short of it is, in my opinion, the term next of kin doesn't exist once you get past the age of 18. And if an event that takes place where capacity is lost, whether it's temporary or long term, then the ability to make a decision is not in your hands anymore, and unfortunately won't be in your loved ones or family's hands either. So things like basics like accessing bank accounts or paying bills, paying the mortgage if it's just one named person on there, just digital assets can't be accessed without permission. But if the person whose accounts they are doesn't have the capacity to give their permission, it really puts the family in a very awkward position. And so the lasting power of attorney under the Mental Capacity Act will give the authority for attorneys who you select to have that authority, whether it's limited or full authority, for your personal property and finance decisions, and then there's a separate one for your health and welfare decisions. So that's in a long and short of it. That's what an LPA is.
And when should somebody consider creating an LPA?
As soon as you reach 18, as far as I'm concerned.
Okay. I've got a question for you in the comments.
Yeah.
So would you advise landlords who have more than one property to have their properties in a limited company?
Ooh. It's kind of like tax advice, but my opinion, and hi Orleans, good to see you. For tax purposes, it makes sense. When I say income tax purposes, or corporation tax is normally lower than income tax. The reason why most landlords will use a limited company, because unfortunately now the law, if you have a property, everything's amalgamated to your personal income, so your tax becomes super high. Whereas if you put it in a separate vehicle like a limited company, then you're separating your personal self, which is a legal entity, to another legal entity, which is a limited company, and then limited companies can offset the expenses like the mortgage costs and any capital costs and other expenses that may incur. And the corporation tax rates are normally lower, typically. Again, this is not advice, but that's the kind of mentality behind that. So really and truly, that's the benefit of using a special purpose vehicle like a limited company for wrapping property in. So yeah, that's what most people do and why they do it, generally speaking.
Thank you, Richard.
No, it's been my pleasure. I've really enjoyed this. Besides the technical issues, I've really enjoyed it. So
it was nice.
So
it was fun. So we'll definitely be doing this more often, isn't it?
Yeah, I've enjoyed it. It's good fun, and thank you for your support, everyone. And leave any comments, below, especially watching the replay. Any feedback, would love to hear. Yeah, fantastic.
And please follow our Instagram page. I've been putting a lot of quizzes there.
Yes.
Yeah, that'll just be fun to see what people think. And yeah, so thank you for watching.
Thank you. Cheers. Thanks,
Bye.
Bye-bye.